2, 3. 1, 2, 3. Does your sound okay? I hope I'm not on the wrong end. No, I don't think so.
Oh, wait a minute, there it is, when I crank it up, yeah.
Do you need another test? Is the sound okay?
Back up. Yeah, I need to do the same.
If I click on the way up, I can look it up, where it's at,
It's blank. Is that the statement? I stand up and I'm gonna be in your way. I don't want to tip you over. Okay. Is that? Closest. The closest. Okay, thanks.
Would you ask her if she needs some time to sit?
Yeah, she does, yeah.
This is a gentleman up here. He says same crap, but I can't remember his name.
Plug in with that if you want.
I should know, but
Yes. Everybody ready? Well, thank you for coming today. The Democratic Party has called this press conference because Oklahomans deserve better than backroom bargains and good old boy politics. Our state is already burdened by having a statewide elected official, the superintendent of schools, drawing taxpayer money, a salary, while under indictment. Now we have the on-again, off-again resignation of Representative Dan Kirby arising from a sexual harassment complaint that was settled in secret. And now, if I remember correctly, a national publication gave Oklahoma an F in ethics last year. Governor Fallin won't fulfill open records request. She has no regard for that legal obligation to transparency and the accountability that goes along with it. And that flows down because what we are seeing right now is the Republican legislative leadership acting like they can spend taxpayer money any way they want in secret without accountability. Now, why was Representative Kirby's settlement hidden in what appears to be the maintenance component of the legislative fund? I'd like for you to all remember that last year the legislature, the Republican legislature, increased its budget. At the same time, it was slashing funds for teachers, for education, for health care, and for roads. Why? To create a slush fund so that they could cover up embarrassments that take place? Our taxpayers, our citizens deserve better than that. They deserve answers to basic questions. Where does the authority come from to take money from an appropriated fund and spend it on a lawsuit like this? Since when does the Speaker of the House have the authority to reach down and take money out himself and just use it however he wants? This is not a settlement that went through the Oklahoma legislature. It's not a settlement that went through a committee of the legislature. It's not a settlement that was done in anything resembling compliance with the Open Meetings Act or the Open Records Act. So where does the authority come from to spend this money? If this had been a state employee, then an investigation would be required before the state could settle a sexual harassment lawsuit on that employee's behalf. There has to be a justification, a determination of the merits of the case. Shouldn't that apply equally when we're talking about an elected official? And where is that investigation? Where are the results of it that the people should see? Because if there's merit to the allegation of sexual harassment, why are the taxpayers paying a sexual harassment claim? If there's not merit to it, why are we spending money when there's no legal basis for liability? These are questions that our taxpayers have a right to hear, particularly in a year when the governor says we're facing a $900 million shortfall again. That once again, our schools will be stressed, our healthcare system will be stressed, our roads and highway system will be stressed, but we can find money to do a backroom deal to cover one of the Republican insiders. Now, that's not right. It should not be allowed to take place, and there needs to be an immediate accounting to address those issues. We're willing to wait a reasonable time period for the legislature to answer the questions, but I note that they have not answered the questions that Representative Inman posed to them on behalf of the House caucus, which are sensible, basic items that need to be addressed. The people of the state of Oklahoma should not be required to wait forever, and we at the Democratic Party are prepared to start a civil lawsuit if necessary, to bring this matter to the attention of the Oklahoma District Attorney if necessary. But before those steps are taken, we call upon the Republicans to do the responsible thing, answer the questions, open up, be truthful, be transparent, be the kind of representative elected officials you are supposed to be. Are there any questions that you have?
I have one.
Yes.
I'm not making light of a serious situation, but it's like watching, isn't sexual harassment one of your areas of specialty?
It certainly is.
Yeah. This is like watching target practice with a shotgun from 10 feet away. Broader issue. Is it time for the legislature to be under all of the open records and open meetings requirements? Or are there some things like emails that should remain confidential? I just want your perspective.
You know, I think the legislature, particularly taking its cue from the governor, has demonstrated that it needs to be under these acts, that there has to be accountability. Every meeting should be open, every recording should be available. All of the communications that deal with the conduct of state business should be open to the people of the state. After all, it's the state's business. It's our money that is being spent. And by golly, we ought to know how and why it's being spent. And if they're not prepared to answer that question, then what are they doing running for office? Their job is to provide those answers and to be trustees for our resources. And they have failed that job. And they've got another F on their ledger for what they've done just in this one instance.
Can you explain the maintenance fund mention in your
You know, I'm not gonna tell you that I know all the details of the maintenance fund, but a maintenance fund by its definition is supposed to be for physical maintenance, for cleaning, for repairs, for keeping up the facilities. So if you're taking money out of that fund, which is what it appears happened, how does that translate into settling a sexual harassment or any other kind of a
Do you have
lawsuit?
documentation on what fund it was taken from and the name of the fund exactly?
No, I think our Democratic leadership can address that better, but that's part of the problem. That's part of the reason why we're asking for accountability, because the Speaker of the House does have that documentation. He's the one who took those funds out, so show it to us. Explain to the public the process that you went through to spend this money. That's not your money. He didn't write a personal check, he wrote a taxpayer check for this.
Representative Kirby, in a statement this morning, says that he was wrongfully accused of sexual harassment and the settlement agreement was made without his knowledge. Can you speak to that?
Well, as a lawyer, I would say that it would be shocking for anyone to settle a case without the knowledge of the person who's the subject of the complaint. You just don't do that. Now, I understand that in these cases, the suits are brought against the employer, not against the sexual harasser. But you're talking about a state representative. If you're gonna settle that suit, then somebody should have talked to him and figured out what was going on. If they didn't do that, that raises two questions. One is, that's not fair to Representative Kirby. The second is, it's not fair to the taxpayers and voters of the state, because we're doing this without any form of accountability, even to the person who's accused of wrongdoing. What kind of a way is it to operate our government in secret without those basic answers?
Is part of the problem that it's part of defense for companies and firms and agencies to have had, modern, last decade or so, kinds of training on sexual harassment. Is that something that needs to be absolutely clarified in the House rules, that there will be such training in the future?
I think actually they have started such training, but it needs to be a regular part of that. But it's important to bear in mind, in a private company, you're talking about private money. With the government, you're talking about taxpayer money. And there are different rules that apply and a different standard that has to be applied. This isn't something where it's my firm, I can spend the money however I want. Dan Kirby wanted to spend his money to settle the case, that's fine, he's got a right to do it. If the Speaker of the House wants to spend his money to settle the case, that's fine. But if he wants to spend our money to settle the case, he needs to be accountable to us as citizens, voters, and taxpayers.
What is the process for a recall petition? Are you familiar with that? If you're not,
There's not a recall position. That's there. You can't recall officials in the state level.
you can't.
No.
Okay.
Local officials.
And can I address the
Yes,
the sexual harassment training? The Democratic caucus has not been offered any type of sexual harassment training. What we know is that the Republican caucus received that training at their Republican caucus retreat. And we only found that out after the news of the settlement came out. And so that training has not been offered to the House of Representatives as a whole.
What was the timing of the Republican training?
I think their caucus retreat was in the first couple of weeks of December. I don't know the exact dates, but it seems like it was definitely it was offered after this settlement had taken place, after this suit had taken place, and it was offered in a partisan manner. So we have asked the Speaker McCall, to give us more information on that training and to offer it to the House of Representatives as a whole.
Retrospectively, do you have any criticism of McCall's handling, like up till last night when Kirby rescinded his resignation?
Yes, the primary criticism we've got is the key issue of taking public funds and spending them in a way for which there does not seem to be any apparent authorization. When you appropriate money, that money is supposed to be spent for the purpose of the appropriation. There was no appropriation to pay for this kind of a claim. When you spend money for this kind of a claim, something that is not part of the official business of the legislature or the representative, there needs to be an investigation and a justification for why taxpayer money should be spent at all, either to defend the claim or to pay the claim. None of those things were done properly, and I have a great question and a great dissatisfaction with not being upfront, with taking the money out of an account that no one would think to look in, to see that a lawsuit was settled from.
What account was that?
I believe it's the maintenance account.
But that would be a criticism of
documentation?
That, well,
Yes.
I, I wish that I could address the documentation. That is what we've asked for as a Democratic caucus. Leader Inman last week asked for documentation of how the money, where the money came from, if it was approved, who approved it, and we still haven't received that documentation. We have heard that it came from a janitorial maintenance account. That was the $16,000 that was paid to the accuser's attorneys was put into that account. So we're waiting for answers on that as well. I'd like to note that the Democratic caucus renews its call for an independent investigation. We are waiting on Speaker McCall to provide us with all of the information as to how this was handled, who approved it. We do realize that this was done under a different speaker and a different administration, and so we recognize that Speaker McCall is trying to get those answers also. But it's been a week, and we expect to receive those answers very soon.
About the 28,000 portion, do you know where that came from?
I don't. I wish that we knew that, and like we have said, the taxpayers deserve to know how this money was spent and who approved it and whether the settlement was even legal in the first place. As attorneys, we recognize that settlements do make sense sometimes, and we don't necessarily disagree with the notion of settling a claim, but we disagree with the way that this settlement was handled. We do, as a Democratic caucus, have an opportunity to propose some new rules that govern the House and how we conduct our business. And we plan to propose some new rules next week at our organizational day. So I would like to turn it over to Representative Perryman from Chickasha to address those rule changes.
And that was Representative Emily Virgin, EMILY-VIRGIN, and I'm David Perryman, DAVID-PERRYMAN. And we've got some proposed rules that have been drafted by a part of the caucus, and those rules have been are being submitted to the whole caucus for presentation. And this is kind of a follow-up of what we spoke about last week when Leader Inman had his press conference, and at the tail end of that we talked about some of the rules that needed to be changed. In the interest of transparency, to answer a couple of questions, we learned of the fact that the portion that was paid to the claimant's attorney came from a housekeeping fund. I believe that was reported by a news source. I believe that either the original news source by the Mr. Clay, the Daily Oklahoman, or by one of the other news sources that had discovered that. And we don't have that documentation, but that is one of the 21 questions that a week ago was asked by Leader Inman, and we're looking for responses to those. One of the other questions is we have no fault with Speaker-elect McCall. We are concerned that it's taking a week to get some of the answers. Some of the answers were pretty simple, easy to answer, and should have been submitted back. We understand that he says that he was unaware of the settlement, unaware of the entire situation until he says he learned of it the same time we did. One of the concerns in that is, though, that someone in the Republican caucus had to know what was going on, because someone set the format at their retreat. I believe that occurred, I believe December the 6th, 7th, something like that, in Durant. And I believe at that time they had a speaker come in and talk to them specifically about sexual harassment and anything to do with using your position to take advantage of the situation as far as power and things like that. And it's my understanding that that did occur at the retreat, and that was about 2 weeks before any of this other came to light. And so someone had to know that something was going on, because you know, why else would there be a feeling that the entire Republican caucus would need to have that training? On the other hand, I would commend whoever decided to have that training, because if this isn't a one-time occurrence, and you know, that's something that I would commend Speaker McCall if he set that up in doing that, to address it and try to cut off future claims. With regard to the rescission of the resignation of Representative Kirby, you know, that came as just as much a surprise to us last night as his original resignation did. You know, I think when the original news release was done, one news source said that there was possibly additional complaints that were being filed, and of course we don't know whether those were additional complaints by other legislative assistants, whether those were legislative complaints that were, or those were complaints in the nature of an EEOC complaint or tort claim that may have involved some other representative other than Representative Kirby, some other representative in the Republican caucus, and I don't know how that impacted Representative Kirby's decision to rejoin the caucus and to rescind his resignation. Maybe it's just conjecture, but maybe he felt like that he needed to be a member of the caucus again to, if there was any sort of protection, he might have been in a better situation as a member of the caucus than not a member of the caucus, if those other complaints are against him. Once again, we don't know that, and we're trying to find out those additional complaints. What you've been handed are about 4 rules, and these are basically the same rules that I mentioned at the last press conference that needed to be looked at. These have been looked at, and once again, what they are is for the taxpayers of the state of Oklahoma, this is an attempt to add transparency to the operations of the House. You know, normally when we study 7th grade government, we talk about checks and balances, and when you've got a state that is where every statewide elected office and both houses of the legislature are all in a Republican, and in the case of the legislature, supermajority Republican, there's no checks and balances. There's no checks and balances on the operations and how an agency or a department works. No one's looking at them to determine whether things are being handled properly. And you know, that's up to the voters of the state of Oklahoma have reached the determination that they want statewide elected officials to be Republicans, and that's their choice. But when you have a void of checks and balances in the legislature, you know, there's not a lot under the current rules that can be done to check the power of the majority. And what this does, Rule 1.5, as you can see, the underlined portion is new language. And basically it says, it asks that anytime the speaker signs warrants or makes contracts, that within 48 hours, that any activity along those lines that deals with the financial, with the use of public funds, that within 48 hours, the leader of the minority party be notified, be given that documentation, and so you know, at least in that case, this would not have gone on for literally months and a long period of time after the claim was filed, and also after the council was retained, because apparently the speaker utilized House funds, public tax dollars, to authorize the hiring of outside counsel, and that's Rule 1.6. And it also says that The minority leader shall be notified electronically anytime outside counsel is hired for any sort of claim like that. And then Rule 3.1 deals with employment by the House and adds a little more transparency to who's being hired by the House for House staff. And then Rule 11.2 talks about investigations, and it requires that anytime there's an investigation that the minority leader be notified. You know, we understand that there are times that there needs to be some sort of confidentiality when a member of the House or someone is accused of something. But just because the Speaker knows that, and just because the Speaker's caucus knows that, doesn't mean that the minority leader should be entitled to share in that same information and be told this is confidential. And, you know, this shouldn't be used for political purposes. That's, you know, but anytime you have that information that is solely within the purview of a single caucus, and these allegations and the way that this was handled with public funds is absolutely you know, the best case scenario for showing that there needs to be change in the disclosure, and that these rules need to be changed to open this up more. Some of the other things that our caucus is looking at, and I've spoken with Representative Virgin about this, is that we do need to file some legislation, and some of that legislation could be along the lines of applying the Open Records Act, the Open Meeting Act, that it's, you know, to various processes in the House of Representatives and in the legislature. I think there's some of the same potential for problems in the Senate, and we talked about that, and I believe that there will be some of that legislation filed. The document that you've got, as I say, has not yet been approved by our full caucus, but we have part of the leadership have looked at that, and that language will be submitted for resolution on the organization day.
Chairman Hammons, is there anything that prevents Representative Kirby from rescinding his resignation?
I have not researched and found anything that would prevent that at this time. I think until the resignation is formally accepted and implemented, that it can be withdrawn, but I'm not going to tell you that I'm sure about that.
Will you ask for an AG opinion on his resignation?
Well, you can ask for an AG opinion. I don't know that we would get that in a timely fashion that would give a clear answer. It does need to be addressed. I don't recall a time period where someone has resigned and then rescinded their resignation as a public official at the state level. So it's a new thing that we're going through. And the only bright side of it is that it points out dramatically what needs to be done. People may have elected Republicans, but they did so by investing trust that they were going to serve their interest and the public interest as a whole. They didn't elect them and say, you've got a blank check, do whatever you want and don't tell us about it. And that's what happened here. And isn't it shocking to have the Republican Speaker of the House say he doesn't know what's going on with regard to this settlement? Well, then what in the world is going on in the state of Oklahoma when the head of the House Republicans, when the Speaker of the House doesn't know about settlements for one of his own House members, how it was funded, how it occurred, and can't supply the information? I don't necessarily blame this Speaker, but there's somebody to blame. That doesn't happen just out of the blue. There are people who made calculated decisions, and it looks like every one of those calculated decisions was to keep the people in the dark. That's not Oklahoma. That's not good government.
How long are you willing to wait? How long is it reasonable? Is it days, weeks?
A matter, I would say, of days, maybe going into the next week. This is a holiday period, I understand that. So, you know, maybe a week or so. But beyond that, then, you know, you've got Gary Scott, the state auditor, who has the authority and the duty to investigate this. You have the Attorney General.
Gary Jones.
Gary Jones, I'm sorry. Gary Jones has the duty and the authority, no, has the duty and the authority to investigate this. You got the Attorney General who has the duty and the authority to investigate this. You have the House itself, which has the duty and the authority to investigate the conduct of its members and the expenditure of its funds. And you have the District Attorney, who has the duty and the authority to enforce the laws of the state.
You mentioned potential civil action. What would that look like?
Well, it's not unusual for taxpayer suits to be filed to demand an accounting for the use of publicly appropriated funds and to challenge the legality of those appropriations. The Oklahoma Supreme Court has been pretty generous in saying that any taxpayer has standing to do that. Remember when Governor Fallon was going to take money that had already been appropriated and then withheld because of a financial miscalculation in her office and tried to distribute it as she saw fit. She was sued under exactly that principle. That money had been spent, had been authorized, wasn't hers to give out anymore. Well, that's the same sort of a basis where, if necessary, civil action can be filed, challenging the legality of the expenditures and requiring that somebody come forward with the justification of how this is lawful, who authorized it, and where the money came from. And if that's what it comes to, then we're prepared to go that course.
Grant, to give you a perspective.
Could you pull that microphone down just a little bit?
Yeah,
It's
sorry,
right
it's in
your
front of my face.
There you go, thank you.
Grant, to address how long we're willing to wait, I agree with the chairman that it is a matter of days, but we have to get this out of the way before session starts on February 6th because we're facing almost $1 billion in our budget shortfall. And we have to address teacher pay, we have to address the teacher shortage, we have to address healthcare, we have to address a myriad of issues during session. And from what I've seen, public trust is at an all-time low right now because of the way that this situation was handled. And I believe it's our duty to get all the facts out and restore that public trust so that the public knows that we're being good stewards of their taxpayer dollars in the upcoming legislative session.
If you don't get that kind of cooperation, do you think House members might introduce a resolution for impeachment?
That has not been discussed within our caucus. We think that while the claim, we don't know the validity of the claim, we don't know any of that yet. What we're focused on is finding out all of the facts and finding out why taxpayer funds were spent this way and if it was even legal to do that.
Are there any grounds for impeachment? I mean, he's not being convicted of anything.
I can't really speak to that. Representative Perryman may be able to speak to that. I've not been in the House when any impeachment processes have taken place. I know that there is a process to censure a member, but that doesn't have much of an effect legally. We can't force Representative Kirby out of office because there's no recall election. There's no recall process.
Are you disappointed he rescinded his resignation?
I can't say that I'm disappointed or not disappointed. I think it just highlights the fact that this entire situation was mishandled, and that the Republican caucus doesn't really know what's going on right now, and it highlights the fact that we need answers as quickly as possible.
My question is for you two that have faced the election process is, it's not my habit of asking softball questions, including of Democrats, but hasn't, David, you might be able to speak to this, Emily also, haven't every step of the way, hasn't this issue been compounded by the way it's been handled? Is that a fair
Absolutely.
opinion for a commentator
Absolutely.
offer?
I mean,
and give me your view, because it seems if you've been handled right from the beginning in terms
Right.
of process, the whole thing would be less salient than it is right now,
Right.
as you put it in the interim.
Right.
It has been mucked up. I mean, it's been mucked up by a resignation that now the member that submitted the resignation said, oh, I didn't do that legally, and so it was never effective, or it can be rescinded. And there's a couple of statutes in answer. Is it Barbara's question, you know, there's a procedure in Title 26 that deals with submissions of resignation, and that deals with elected officials that have to be filled by special election, but it's a general statute.
Yeah.
And it requires the submission of the resignation to the Secretary of State. And then in Title 51, Section 9, there's a more specific provision that deals with members of the House of Representatives and how that's supposed to be submitted. And it says it's when we're not in session, it's to be submitted to the governor, and when we are in session, it's supposed to be submitted to the presiding officer of the House. And of course, you know, who's the presiding officer of the House right now? And we're not in session, and you know, we've got a speaker-elect, but has it been formally installed? And so, how does that all play out? And but it does say that when the presiding officer of the House receives that, and we're not in session, he should immediately forward that to the governor. And you know, and that sounds to me like a ministerial act. And when you've got a ministerial act, you know, that of course, you know, that's courts make great distinction between ministerial acts and acts that individuals have discretion to do. So there's some real questions there. The only time that that statute has been interpreted is in the case of a sheriff in I believe Latimer County several years ago, and the resignation. The court went right to the point of making a determination on whether that could be rescinded. You know, the Title 26, the reason this is important is the Title 26 procedure says that it can't be rescinded, that it is an irrevocable. I think that Senator Kenneth Corn, had actually, that was part of his legislation back several years ago, and that's in the election code. And so that's, you know, that's we've got some conflicting information there, but anyway, you know, to say that we're disappointed or happy or whatever as far as the status of Representative Kirby, we're neither. I mean, if Representative Kirby didn't do what the allegations are against him, he needs to be a member of the House, and he needs to stand his ground. And but that's not what all this is about. What all this is about transparency and the fact that taxpayer money has been spent, without any sort of transparency or disclosure. And that's what we're trying to do, is to find out the answers, because there's not a checks and balance. You know, it would be nice if the state auditor or the attorney general or the governor or even the current speaker, if someone would have weighed in. You know, it's really nice if in the ideal world, a caucus would discipline its own members, or at least take a position with its own members. But
are you still content to let the former state chairman of the Republican Party, the auditor and inspector Gary Jones, do the financial part of this, looking at House finances and procedures?
Patrick, one of the things that I can say is the voters of the state of Oklahoma chose Gary Jones to do what he's supposed to do. And I'm not going to say I trust or distrust that. I hope that he does what he's supposed to do. And I hope that...
Does he have to have a request under process for McCall?
I don't believe so. I don't believe so. Not to look at this. Now, if the question were, are you looking at the activity that Representative Kirby did, yes, that's outside the purview of the state auditor and inspector. What we're saying is something needs to be looked at as to whether the funds were improperly appropriated, improperly spent, and that is a matter that I don't believe anyone has to request the state auditor and inspector to look at. Questions?
Any other questions? Thank you all.
Thank you.